Joining us this morning to dive a little deeper into this possible legal issue, our chief legal analyst, Khalif Rhodes. Khalif, good morning, my friend.
Good morning. Long time no see.
It's been a minute since I've been in here with you. All right, so let's dive head in first to this. Two questions. One, are you surprised that they said, no, we're not going to revisit right now, 10 years later? And then two, what would it have taken for them to go, okay, let's open this up. Let's look at it.
5 folks like Clarence Thomas. I'll answer the second part. Clarence Thomas has already initially said that he wanted to address this case in the past. He said that he wanted to address same-sex marriage, birth control, and same-sex intimacy. So this is something the writing was on the wall for Clarence Thomas. If there were 5 folks that were like him, then we would have had this case being heard. But they weren't, and so now we didn't. But on the other side, I think it would have taken a lot to get to that point. But am I surprised? There's about 6,000 or 7,000 cases that are submitted to the Supreme Court every year. They only take 60 to 70 of them. That's 1%. So there was a 1% chance that her case would be heard, even if she had great facts. And these weren't great facts. You're asking the court to do a number of things that they historically don't want to do. They do like to look at cases that have constitutional questions. First Amendment is a clear constitutional question. She did raise the issue in the lower court, but the court rejected that issue. They said, look, you were acting under color of law in an official capacity. You sometimes will have to set aside some of your rights because now you're going to attempt to trample on someone else's rights. Because of your official capacity, you have to act in your capacity and set aside your other obligations. And that was the ruling of the lower court. She appealed it, and the Supreme Court said, we're not going to touch it. While they don't give us a rationale as to why they don't touch it, if I had a crystal ball, that's the clearest reason as to why.
Well, and speaking of that, justices didn't make any comment, right? How often do we see that with such a big case like this one, where they say, we're going to take it up, but we're not going to tell you why?
Yeah, that's the norm. It's denied. It's a one-line sentence.
And they don't have to tell you.
They don't have to say anything. I mean, much like we've seen in the most recent months with these emergency docket type of cases that have been on there where they're listening to them and they're overturning something on the lower court and they're not giving a rationale why. They don't have to give you any rationale on those decisions. However, the court has in recent time given a rationale in those emergency decisions. But historically, when denying cert, denying an opportunity for your case to be heard in the Supreme Court, there is absolutely no history of them saying, yes, I'll give you a reason as to why I've denied your request. It's just simply cert denied. I mean, that is the sentence. No rationale, no basis. And so this was unanimous. There was no dissent. Typically, you would know who and where the party lines landed. But no, you didn't get that with this one. It was 100% unanimous that everyone agreed that cert should be denied. And I have to overemphasize, you need good facts. You need good timing. You need a good court. If you had 4, I should say, not 5 individuals, because that's what's needed to get cert, that felt like Clarence Thomas did, this case would have been heard.
Khalif, remember 100 years ago when we were kids and you had those choose your own adventure books,
oh,
right?
Yeah.
If you want to go through the mountains, turn to this page. If you want to go down the river, turn to this page. In this instance, let's choose, had this been revisited, had it been overturned 10 years later, what would this look like here in the Carolinas? Because this now would have been a state-by-state decision, right?
It would have been and we don't have to look far to figure out what it would look like. Just look to what happened with abortion. Yeah. The Supreme Court said abortion is not a constitutionally protected right. We're going to kick it back to the states. And when we kick it back to the states, each and every state can make their own, choose their own adventure, make your own determination. And so every citizen in those states have to make a determination. Quickly, I'll say this. Since last year, there have 10 states that have adopted language, Texas being one of them, that say judges are now allowed to refuse to perform same-sex marriages due to religious beliefs. So it's already opened the door. Even though it's a protected class, those states adding that on the books have opened up their states to litigation and maybe changes in the legislation.
Interesting. So again, as always, something to keep an eye on, and we'll see what happens. Khalif, thank you.
Queen City News Plus. Just search Queen City News on your smart TV's app store.